The proceeding will start shortly. 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 The proceeding will start shortly.
Can I welcome you on behalf of the committee? Thank you very much indeed for giving up your valuable time to give evidence to us this morning. We've been so speedy, we're starting 5 minutes early. I hope that's not going to cause you a problem. Can I welcome Michael Clancy, Director, Law Reform, the Law Society of Scotland, Professor Nicola McEwen, Professor of Politics at the University of Edinburgh, and Professor Alan Page, Professor of Public Law at the University of Dundee. Can I kick off with a question about the Scottish Government's proposal that Scotland should find a way of remaining in the single market while the United Kingdom leaves the European Union? And I'd be interested in your view, firstly, on whether you think that is feasible, and in particular, whether you can shed any light on what you think the attitude of others, because there's been a lot of focus on the proposal being put by the Scottish Government to the government here in Westminster, and saying, what do you think about it? But what can you tell us about the view of others in Europe about the likelihood that they might or might not agree to this? I don't know who would like to kick off. Professor McEwen, it looks as if it falls to you.
I think it's a credible proposal that merits examination.
Right.
Obviously, it would raise lots of challenges. There are lots of complexities. The practicability of the proposal, I think, would depend on what Brexit turned out to mean. So the nature of the UK-EU relationship might determine how feasible that proposition would be, and we don't yet know what that will be. But I think you're right to imply that some of the biggest challenges are around political will. Political will within the United Kingdom, first of all, and then political will within the rest of the European Union. My understanding is that the position that most EU member states have taken is that these are domestic matters, and any proposal would have to come as part of the UK government's proposal and negotiations before they will make a judgment. I suspect there would be concerns about a part of the United Kingdom remaining within the single market, and some of the issues that might create in terms of fairness or access for the other member states. So I think that there are enormous obstacles in the way of political will at different levels, but I think it matters. It may have broader political implications for wider debates on the Constitution at what stage the proposal was blocked, whether it was blocked first within the United Kingdom or whether it was blocked further down the line.
Mr. Clancy, Professor Page, do you want to add anything on that?
I think the only thing that I would want to add is that the proposal implies that Scotland would continue to adhere to the acquis communautaire. It would have to. That would be part and parcel of being part of a member of the single market. At the same time as the rest of the United Kingdom was assuming the freedom to go in a different direction. And if that were to happen, if you were then to have a divergence in requirements between Scotland and the rest of the United Kingdom, that in turn would have implications for trade within the United Kingdom.
Mr. Clancy?
Thank you, Chairman. I think that it is the case it's more a political question than a legal one. But when one looks at the Scottish Government's paper, it starts off with looking at the UK's position within the EEA. And as we know, in order to become a member of the EEA, you have to be in either the EU or EFTA. And I think Judge Karl Baudenbacher, who is the president of the EFTA court, has recently explained that in very succinct terms in lectures which he has given across Europe over the last few months. So therefore, bearing in mind that the EEA agreement is an agreement between the EFTA states and the EU states, it's difficult to see how one could be floating in between the two. So therefore one would have to be either in the EU or in EFTA to participate in that kind of way.
And is there any precedent that you're aware of for any entity other than a state acquiring either of those forms of status? No.
We're clearly in uncharted.
Uncharted,
territory.
okay.
Very much so.
That's very helpful. Thank you very much indeed. Joanna Cherry.
Thank you very much, Mr. Chairman. Mr. Clancy, good morning. I wonder if I could start with you. In the various commentaries the Law Society has put forward since Brexit, since the Brexit vote, you've talked about the importance of ensuring a whole-of-government approach within the United Kingdom. Can you explain to us what you mean by that?
Yes, thank you, Ms. Cherry. Mr. Chairman, when the vote happened in June, Bernard Jenkin, who was chairman of the Public Administration Committee, wrote to Oliver Letwin explaining that he thought that this was a whole-of-government project. And taking up that theme, we analysed exactly what one could interpret that to mean, and I think it's fair to say we came to the conclusion that it wasn't simply a whole of UK government project, that it had to involve the devolved administrations, and then tweaking that idea slightly, you can get from whole of government to whole of governance, and that involves engaging with civic society and other bodies so that we get the fullest impression of critique on the proposals from the government in terms of the white paper and what is to come, and also make sure that there is a degree of consistency and agreement as to the way forward. And I think that that is really what we were intending to convey when we were saying that it should be a whole-of-government project.
And do you think that the way in which the British government is handling the process so far is achieving that objective?
Well, that too is a political question rather than a legal one. And you as a politician are far better placed to answer it than I. But clearly the creation of the Joint Ministerial Committee for European Negotiations is a step in the right direction, and we applaud the idea of that. It's up to the participants in that joint committee to make the best of it that they can.
Professor McEwen, can I ask you as a more political question whether you think the Joint Ministerial Committee process is working effectively?
It's very difficult to tell because it so lacks transparency, as the Joint Ministerial Committee in general does. I mean, certainly there are more intense intergovernmental relations through the JMC in various forums now as part of this process than there has ever been. But we don't yet know if... So the Joint Ministerial Committee European Negotiations had quite a distinctive remit. Unlike any of the other JMCs, it was set up with the specific purpose of trying to reach a common UK position, trying to come to an agreement, an agreed decision. There's no sign as yet that that objective is being able to be fulfilled, and there's certainly frustration on the part of the devolved governments. The Scottish Government has been quite vocal, but frustration also on the part of the Welsh Government about their ability to exert influence through that process. I think the situation in Northern Ireland obviously complicates the JMC process now too, making it, I think, almost impossible to come to a common agreed position prior to the triggering of Article 50, if that's the end of March.
What is it that's frustrating the Scottish and the Welsh governments?
I'm sure you'll have an opportunity to ask the Minister later on, but there's the Scottish Parliament, the Scottish Government now have an agreement that government ministers will report on their participation in intergovernmental processes, and all of the letters that are sent are on the Scottish Parliament website, and certainly if you read those, you can see a I suppose, a sense of frustration that that they're perhaps not consulted prior to publication of, or prior to the Prime Minister's speech, prior to publication of the White Paper. And I'm not sure if that was true or not, but there seems to be a commitment since the last Joint Ministerial Committee plenary, which I think took place last week, that there will be bilateral discussions now between senior officials on the Scottish Government's proposal. I simply don't know enough about how those discussions are unfolding and how serious an examination that proposal is being given.
Are you able to help us with any suggestions as to how the process for consultation and discussion could work more effectively? It'd
be nice if it was more transparent. Obviously, it's appropriate for governments to engage privately, to have a space for frank and private discussion, but I think a bit more scrutiny of that process would possibly help it along the way. I think there's perhaps one illustration in relation to Wales rather than Scotland, where there's maybe a sign of how it might not be working, in that the Prime Minister's Lancaster House speech, which effectively ruled out participation in the single market, came, I think, a day before the Welsh Government's White Paper, which stated its desire to stay within the single market. And that seems to me to be an uneasy situation when the stated objective is to have close cooperation between the governments. The timing of that didn't sit quite well with me.
I wonder if I could ask you a couple of questions about the Scottish Government's proposals in the document Scotland's Place in Europe. You've described it as a credible proposal that merits examination. The Chair asked you whether there was any precedent for any entity other than the state acquiring membership of the EU or the EEA through EFTA, and you said we were in uncharted territory. You'll be aware that the Faroe Islands are currently exploring the possibility of membership of EFTA. Could you explain, for the benefit of the committee, the relationship the Faroe Islands currently have with Denmark and the EU, and what the Faroe Islands are trying to achieve?
Well, I'm not an expert on the Faroe Islands, but it's a federacy, and so it's part of the Kingdom of Denmark, but with a very, very high level of autonomy. I'm not sure that it is a very small island community. It may not offer the most direct parallels for Scotland, a much bigger entity sharing a land border with the rest of the United Kingdom. That obviously adds more challenges and more complexities. If that negotiation bears fruit, and if the Faroes does join EFTA, then that obviously would perhaps potentially set a precedent for an entity which is not itself a sovereign state being part of that organisation, and that possibly throws up more opportunities for the proposal that's on the table. I said it was a credible proposal, but I do think that some of the complexities surrounding the proposal are glossed over in the Scottish Government's paper. There may be more detailed papers that the Advisory Council have prepared, but there are significant challenges, not so much, I don't think, around trade, because the proposal is not for Scotland to be part of the EU customs union, but to be part of the single market. But there are proposals around how you manage the complexities and how you govern the complexities, and I think that would be perhaps more challenging than is discussed in the paper.
Now, you said there that you didn't think there would be challenges for trade, because of course the proposal is that whereas Scotland would be in the single market, it would not be in the customs union if the rest of the UK is not in the customs union. That's correct, isn't it?
That's the proposal. I'm not saying there wouldn't be challenges, there would be a different set of issues. Different set of challenges.
Just to get back to EFTA, this may be more a question for Professor Page, but I'll be corrected if I'm wrong. There's nothing in the EFTA treaty that says a member state has to be sovereign, is there?
Not that I'm aware.
Thank you. Now, Professor McEwen, just getting back to the Faroe Islands, Scotland is sometimes told that it has the most powerful devolved parliament in the world. How does the degree of power that the Scottish Parliament has compare with the degree of power that the Faroese Parliament has?
I'd have to check back the exact measure. It's difficult to have... when you're comparing the degree of power, it can be quite difficult. There are some indexes of powers that are exercised by different entities, but of course they're quite blunt tools because the nature of power, the nature of self-government is different in different cases. I'd have to check back on the exact comparisons between those two. My sense is that the Faroe Islands has more self-government than the Scottish Parliament has. But the Scottish Parliament has a lot of autonomy if you compare it with other entities within even federal states. What it lacks, what the Scottish Government lacks, is the same level of influence. So in political science, we often draw a distinction between self-rule, the powers that can be exercised within the devolved territory, and shared rule, the extent to which they can influence the powers at the central level which affect their competence. And the level of shared rule for Scotland and for the other devolved territories in the UK is smaller generally than most, or lower generally than most of the entities, similar entities in federations, like the Canadians, for example.
And you write a blog for the website Centre on Constitutional Change, that's correct, isn't it? I'm just looking at your blog from March of last year, and I wonder if I could just read out a short passage and ask you to expand upon it. You say, the Scottish Parliaments, if we include the parliaments of regions or provinces within federations, where regional and national parliaments are each sovereign within their own spheres of jurisdiction, the Scottish Parliament's power is on most measures surpassed by the American states, the Canadian provinces, the Australian states, the German Länder. Also, federacies like the Åland Islands or the Faroes have substantial political authority, and they too rank more highly than Scotland in international comparisons on comparative indices like the Regional Authority Index. Yes.
Well, that's the index I was thinking of. Yeah. Sorry, my memory doesn't stretch back to last March to remember the exact rankings of each of the members, but I reiterate the point. The biggest difference with all of those entities is on the level of shared rule, the level of influence, which is one part of the political authority that entities within multi-level states and federations can exercise.
Just going back to this issue of whether or not Scotland could have a differentiated agreement while remaining part of the United Kingdom, we had some very interesting evidence a couple of weeks ago from the Chief Minister of Gibraltar. And of course we heard that whereas Gibraltar is in the European Union, they are not members of the customs union. So would the committee be right in understanding that within the European Union's arrangements as they exist at present, there is precedent for differentiated arrangements within member states?
Yes.
I'm conscious of not overrunning my time, Chair. May I have one more question?
Yes, of course, given the subject.
Professor Page, you prepared an analysis for the Scottish Parliament of the issue of which powers are likely to be repatriated to Westminster and which powers are likely to be repatriated to Holyrood in the event of the United Kingdom exiting the European Union. Yesterday, the leader of the Conservative and Unionist Party, Ruth Davidson in Scotland, in a speech to Scottish farmers, talked about willing to be flexible and pragmatic in relation to which powers went where in respect of agriculture and farming policy. Could you comment on that?
I did see it. I was a little bit surprised by it, I have to say, because agriculture is a devolved competence, and therefore one that one would expect to remain with the Scottish Parliament. And I had indeed assumed that was the case, and there was general agreement that devolved powers would remain where they are. There are, I know, funding issues in relation to agriculture in particular that would need to be addressed. But yes, I was a little bit surprised by it as a statement.
Thank you.
Okay, thank you very much. Dominic Raab.
Thank you, Chair. Good morning, and thanks for attending as witnesses. The EU and many here have made the point about the indivisibility of the single market and its four freedoms, and I just want to drill down a little bit on some of this. If the UK was out of the single market, which is the stated aim, can you identify for me what the positive legal basis would be in the treaties of the wider EU framework for Scotland to remain in the single market? And I perhaps could ask Professor Page first on that.
The short answer is I have absolutely no idea. But if there was an agreement, the agreement would provide the basis for whatever relationship there was then to be between Scotland and the EU. But I cannot, I think I'm right in saying, identify any particular provision in the existing treaties that would cater for that possibility. There is provision in relation to things like cooperation in higher education and so on, whereby there may be a relationship between the EU and other states, non-member states, but I'm not aware of any general basis for such a relationship.
Is there a risk then that any agreement that might be agreed at the international level would risk suffering not being compliant with EU law and ending up in the ECJ, or is it just a question, in your view, that the political will would force it through?
Well, yes, there is the question of political will, which Professor McEwen has addressed, and that would then have to be followed through in the actual ratification of whatever agreement was arrived at. So it wouldn't just be momentary political will, oh yes, we'll agree to this. It would actually have to go through the individual member states' procedures for ratification of that agreement, yes.
And I'm just interested on this aspect, and there's a crude distinction being made between the divorce and the new relationship. Is it your view that this would fall within the terms of the new relationship and the terms that would need to be agreed?
Well, the divorce, as I understand it, is supposed to be negotiated with a view to, or in the light of, the new relationship. I'm not sure there's much more I can say usefully than that.
I'm interested to know, in the absence of a positive legal basis for it, what the voting procedure you think might be for this aspect. Would it be unanimity or QMV?
Well, I think Article 50 provides for QMV.
Article 50 does?
Yes. And therefore I'm assuming that this would be covered by that. But then what we're probably talking about is a mixed agreement, which would require not just the agreement of the EU, but also the agreement of the member states.
So you think that in relation to that, unanimity would probably be required?
I'm not sure if it is required for a mixed agreement, but the point is that all the states would have to agree to it.
All the states. And I just wondered, Professor McEwen, as a matter, we've talked about the distinction between law and political reality, if all the member states would need to agree, bearing in mind the views from Spain to Croatia, do you think it is politically realistic to think that all the member states would agree to such a differentiated arrangement? Your best guess?
Depend on what the nature of the agreement was and what calculations they made and how it affected their internal domestic politics.
But
if
on
you're
the
asking about
specific
Spain
question,
and concerns about the impact on Catalonia, clearly that's present, clearly that is part of the debate. My sense is that the situation that the United Kingdom and Scotland is in now makes it look even less like Catalonia's situation within Spain than was the case 2 years ago. That doesn't mean that the Spanish government wouldn't be concerned about any direct implications for them. And it may not just be Spain, actually. There are other EU member states that have strong regions within their boundaries too, and there may be some concerns about undue influence, or if that was the way it was perceived, or some sort of preferential treatment for what would be considered a region within an ex-member state as part of that process.
Which of the other, we talk a lot about Spain, but you're right to broaden this out, which of the other member states with federal systems do you think might be most apprehensive, let's say, about individual federated parts having bespoke arrangements? Who would be the top three on your list beyond Spain?
Belgium, probably. And Belgium is interesting here because in the nature of a mixed agreement, as we just saw with CETA, then that's a decision that would also be taken by the regional parliaments as well. Italy is not a federal system, but it is a devolved system, so it has those sorts of territorial issues as part of its politics. But I don't think the issue is just about internal territorial dynamics. I think there are broader, we can anticipate that there may be broader concerns on the part of some member states, irrespective of whether they have those territorial issues to contend with, about a part of the United Kingdom having access to the single market and what that might mean for their own interests, their own national interests, and the four freedoms issues.
Thank you. If, and I want to try and think about game this out in my mind, if the UK was out of the single market and Scotland remained in, there would obviously be differentiated arrangements for free movement in the two parts of Britain. How would you envisage on the notional, let's say, border between England and Scotland, how would you envisage those arrangements what arrangements could make that happen? Perhaps first of all, Professor Page.
Yes, the border implications. I have to confess that not having thought this through or thought seriously about it. As regards the particular question of immigration, there is, as you know, talk about alternative methods of immigration control that would not involve actual border checks, and which it is argued could be as effective or more effective than border checks, which would remove one argument in favour or one justification for a hard border. And then there is the analogy with Ireland, which has been drawn rightly or wrongly. But beyond that, I don't think I have anything to add.
I wonder whether Professor McEwen or Mr. Clancy, you had a view on that.
Our committee has recently been talking about what might be the sort of shape of this, and of course different immigration rules could come into that. As we know already, the border is in a sense pushed back beyond the ports and airports into areas where immigration status is checked by the health service, by landlords and other service providers and local authorities and things like that. There is a different tax code for people resident in Scotland with an S at the beginning of the code to identify that person as a Scottish taxpayer. So there are mechanisms which already exist which with a bit of imagination could be applied to this kind of situation where you would be able to identify people who were Scottish residents as opposed to residents of other parts of the UK.
Would I be right in thinking that if we went down that route, effectively Scotland would be a route for free movement into the whole UK, but you would apply law enforcement powers to try and curtail that? That seems to be the model you've expressed, but I don't want to caricature it.
You're right not to caricature it. I think clearly at the point of law enforcement, then when if someone were found to be continually resident in England and applying for benefits or seeking healthcare or something like that, then that person would be flagged as being a Scottish resident if we adopted some kind of differential immigration rules. What the consequences of that would depend on the particular circumstances of the case.
Finally, I just wondered if Scotland stayed in the single market but the UK was not, whether anyone has done, north of the border, so to speak, an independent assessment, i.e. from government, whether UK or Scottish, of the net impact it would have on immigration into Scotland of this differentiated arrangement of UK out of single market, Scotland in. Professor McEwen, are you aware of that?
I know that some of my colleagues in Edinburgh are doing some work on this just now, and also looking at the feasibility and implications of a differentiated immigration set of rules. I think that there's probably a distinction to be drawn between labour market mobility and freedom of movement more generally within the common travel area, and some of these issues around common travel area movement are already being discussed for Ireland, obviously, and that would have implications for Scotland and the rest of Britain as well. But
sorry.
Around, sorry.
Yes, no, I understand that, and I'm sure there's a huge amount of work going on, the technical aspects and arrangements. I just wondered
in terms of numbers?
Yes.
There was some evidence given to Scottish Parliament committee just before Christmas, I think, that tried to model some of the long-term impacts on reductions in inward migration. It's difficult to model because we don't know whether and by how much it would be reduced, but I think there were certainly some concerns about the impact it would have on dependency ratios, and given the age profile of EU migrants being younger and more likely to have children than the rest of the population within Scotland. So there were some concerns about not just the overall numbers, but the impact it has on longer-term issues around dependency ratios.
Have I got time for one more, Chair, or not?
If you're very quick.
I just wondered whether, to each one of you, we talked a lot about the risks, and I can understand that, but if we think of the opportunities of leaving the EU for Scotland as well as the UK, I wondered whether it was fisheries or the devolution of powers back to Scotland that we take back from Brussels, or export opportunities, whether you had in your mind, notwithstanding the risks, which are understandable, but particular concrete opportunities that there would be for Scotland. Perhaps if you have one each, that would be wonderful.
Well, I think that is a useful way of thinking of it, and I think from a Scottish perspective it is important to think about this not just in terms of in the single market, not in the single market, but what are the things that matter to Scotland vis-à-vis our relationship with Europe as it is now and as it might be in the future. And I think it's only when you get down to that level that you can begin to make a proper assessment of the advantages and disadvantages, benefits and disbenefits of where we might end up. Professor McEwen?
Probably the most obvious is around the area of competition policy and some of the constraints that has introduced. The most visible is around minimum pricing for alcohol, which was blocked at least for a while, or around concerns about competition. My own research a couple of years ago also looked at energy and the development of renewable energy in communities and in the islands, and there were some difficulties there of being seen to unfairly subsidise in those competition. From that competition perspective, some quite vulnerable communities where you wanted to have extra subsidy or added enhancement for development in those areas. So those are some of the areas that may be possible depending on the nature of the new regulations.
Thank you. Mr. Clancy.
Thanks very much. It's an intriguing question, and if we take it to the Great Repeal Bill, then the Great Repeal Bill may offer opportunities in terms of extending the competence of the Scottish Parliament. The competence of the Scottish Parliament at the moment is constrained by having to comply with EU law. If EU law is domesticated, then in a sense that restriction flies off, and that allows us to look at the principles which should guide us in terms of reconstructing the supranational legal order into the domestic legal order. And those would be things like adherence to the rule of law, making sure of access to justice and that the proper administration of justice should be followed, and that we would acknowledge more acutely, in some respects, some principles such as subsidiarity and proportionality, which might apply at the moment only in the EU sphere, unless you take into account the general localism agenda.
Thank you.
Thank you. Can I just, one follow-up question? You discussing the possibility of Scotland remaining part of the single market. Now that would be, if it were agreed, part of the Article 50 agreement. But then, in answer to questions from Dominic Raab, I think you said that all member states would have to agree. Can we just be clear as a committee, would it also require a change to the EU treaties in order for that to happen? I know this is uncharted territory, but it'd be helpful to know, because clearly if it requires a change to the EU treaties, then not only do all 27 member states have to agree, but those states that require referenda in order to approve changes to treaties would be faced with the prospect of having a whole load of referenda on this change.
I'm assuming it would be an association agreement rather than an amendment to the treaties.
Right. Okay. Very helpful. Thank you. Mark Durkan.
Just to come back to some of the points that have been touched on, I suppose relating to the Great Repeal Bill and other matters. First of all, which policy areas where the EU currently exercises competence would you expect to come to the Scottish Parliament when the UK leaves the EU? And also touching on the particular point that was made by Mr Clancy, beyond those that are currently in the EU competence that would or may transfer, which are the areas that are already in Scottish competence that are subject to restriction where significant differences might open up?
Well, the Scotland's Place in Europe paper, which the Scottish Government has published, indicates those areas where the EU currently holds competence, where one might expect further devolution: agriculture, food and drink, fisheries, aspects of environmental law, criminal law aspects in terms of the European arrest warrant and things like that, and health, higher education and research, and particularly civil law matters. And this is a point which is not picked up in the government's white paper, although some aspects are, such as criminal law being repatriated. But civil law matters are crucially important, and we ought not to omit or overlook them, because they relate not only to commercial legal transactions and the enforcement of judgments and things like that, but also very personal matters, such as the jurisdiction for family law questions, maintenance issues, and things of that nature. And these are of deep importance to individuals the length and breadth of the country. So I think that I would like to highlight that particularly as being one of the areas which would be repatriated, but it's also something which the UK government ought to have included in the white paper, and we ought to remind them of that.
In terms of the list that you reflected from the Scottish Government's paper, they are not all of a kind and on a par when it comes to possibly linked funding questions, and refer to what Professor Page had said earlier in terms of agriculture. So what thought has been given to whether or not there could be different journeys for these powers? Will some go directly to the Scottish Parliament? Will some go through some sort of transit arrangement, vaguely in the UK, in some sort of holding pattern in Whitehall or Westminster? Or how when we look at those list of competences, what journey is planned?
The brief answer to the first part of your question, which powers are currently devolved but are the subject of EU competences, the ones I listed were justice and home affairs, agriculture, fisheries and the environment. These are the key ones so far as Scotland is concerned, and the ones that you would expect to remain within the Scottish Parliament's competence. You're then talking about what additional competences, what additional powers might be devolved, and as Michael Clancy has said, there is a long list in the Scottish government's paper, Scotland's place in Europe. Now, I would expect that to be part of the negotiation within the United Kingdom that's going on at the same time as the negotiation between the United Kingdom and the EU, so that there would be an agreement, as the UK government's white paper in fact anticipates, as to which powers will end up where. And it states in that white paper that it is open to the possibility that there should be further devolution, but at the same time it sets a limit to that process by saying further devolution should not lead to the introduction of additional or new barriers to trade within the United Kingdom, which is the point that I made in the work that I did for the Scottish Parliament, namely that many of the reserved competences are UK single market related. That's why they're in Schedule 5 to the Scotland Act and the equivalent provisions in the Northern Ireland Act. So I would have thought that rather than being in a holding pattern, there would be an agreement that these powers would be devolved, however extensive or limited the additional powers are to be. But allied to that, there is this key question of funding. How is agriculture or a UK-wide Scottish, Northern Irish agricultural policy to be, farming policy to be funded when the United Kingdom leaves the European Union?
Well, it's exactly that point. You've said which powers end up where, and the question then surely is going to be what the journey of those different powers might be. And it may be different for different powers, not least because if we're talking about something like making laws on environmental standards, that is something that is a straightforward matter of legislative competence and administrative enforcement. Agriculture, however, brings in the whole question of agricultural support payments, which obviously are EU derived, but the money comes as annually managed expenditure. So the Treasury may well have a view that says they would need more time in relation to those competencies that have involved public expenditure by the AMI route, and therefore they should be taken in a different class from other things. Has anybody anticipated those kind of issues?
That's an interesting point, because powers and money in terms of devolution have been dealt with entirely separately. So the devolution legislation says absolutely nothing about money, and that's the subject of separate funding agreements. But so far as the powers are concerned, I'm just thinking about the Scotland Act 2016, which provides for the phased, if you like, delegation or devolution or transfer of powers in relation to, for example, welfare. So there is no reason at all why you could not build into whatever agreement a system whereby powers were not just devolved, there you are, get on with it, but it was done in a more orderly, structured, thought about way. But yes, and the separate question of the money that goes with that. Yes. But could I just add one point in relation to that, of course, which is that in terms of funding, the funding settlement in the UK, the money, the block grant comes without strings attached. It's not tied to particular programmes, so it is up to the devolved administration to spend that money.
But that's not so with AMI spending, annually managed expenditure, which is the form of expenditure that is used in relation to agriculture.
Yes. Which is not an issue.
And I'm not going into Northern Ireland experiences on welfare reform or other things. Professor McEwen, you?
Just on that point, I wonder if it may be insightful to think back to the discussions around money in relation to the devolution of social security, or partial devolution of social security in the Scotland Act 2016. Social security, as you know, is AMI funded too, but my understanding is that they couldn't identify a sustainable way to maintain that in relation to the devolved social security competencies. without issues of parity, which were not what either government wanted.
Yeah.
So there is a possibility that that sets some sort of precedent around other AME-funded projects that are now the subject of fiscal transfers post-Brexit. So just a note of caution on that. On the broader point about the repatriation of competences, there's an awful lot of ambiguity, I find, in what the government white paper says and what the Prime Minister's speech said about what the repatriation of EU competences may mean for devolved competence. There's the commitment to ensure that the devolved governments or the devolved parliaments do not have less power than they currently have, but that's quite distinctive from saying that they will have an awful lot more power, and it doesn't preclude it, but it's at the very least ambiguous, and it seems to me to be an obvious source of tension as the negotiations get underway.
Well, in that context then, as we await the great repeal bill, the great download and save bill, at what point would the consent of the Scottish Parliament be required to terms within that bill? Would the consent be to the bill at large, or would the consent be specifically to those areas that would directly address the competence or future competence of the Scottish Parliament?
The assumption is that the Great Repeal Bill will require legislative consent motions. Now, that will mean that consent will be sought to particular provisions, or these will be the provisions that require consent. It will be on that basis, but again, going back to previous examples, the Scotland Act 2012, the Scottish Parliament at that time said, this was too big a question to just give a yes or no answer to, and there was a lot of toing and froing before an agreement was eventually reached. Yes, it will require consent, and I would have thought that process the process of securing consent, if I can put it like that, would inevitably take in all aspects of the proposed settlement that were of interest to the devolved legislatures.
So, but in respect of the Scottish Parliament, do you expect that the Great Repeal Bill would be subject to an omnibus legislative consent motion that deals with everything that says, or would there be bespoke legislative consent motions in respect of how particular competencies are addressed, some of which may be coming straight away, some of which may be pending other negotiations?
One bill, one legislative consent motion, unless the bill is to be substantially amended. But you have the possibility, of course, that we're not talking just about a Great Repeal Bill, but also about amending devolution legislation, which would be the subject of separate legislative consent motions. And there must be a limit to how much you can put into this Great Repeal Bill.
Thank you. We if that's okay, we need to move on. Peter Lilly.
I would find it helpful if someone would explain to me what is meant by the term single market. I had to introduce the legislative consequences of the Single European Act, which doesn't mention the single market, it mentions the internal market of member states. It's not clear to me how one can be a member of the internal market without being a member of state. So do people, when they're talking about single market, mean the European Economic Area? And if so, why don't they say so?
My understanding is that all these terms are in a sense interchangeable. The first term we had was common market, which then became the internal market, which you're referring to as a result of the Single European Act, and is now referred to as the single market. But, as defined by, I think it's Article 6 of the Treaty on the Functioning of the European Union, it is an area in which the four freedoms, the free movement of goods, persons, services and capital is secured.
But there isn't any mention in European law of the Single European Act outside the European Economic Area?
No.
A single market, right? Yeah. So we're talking about Scotland being a member of the European Economic Area. and that means it would have to adhere to European law across a wide range of activities, but have no say in the making of that law, no power to amend that law, no power to repeal that law. Is that correct?
That is correct, yes.
Isn't it odd for a party which claims to be in favour of devolving power for Scotland to be in favour of moving from a position where it has some influence over all these laws to having no influence over all these laws? It seems to prefer to have no influence over lawmaking rather than share that influence with the rest of the United Kingdom.
That's possibly a question for the Minister rather than for us.
I'll give it that to her.
Yes.
But all member states of the European Economic Area accept the supremacy of European law, effectively through the EEA court. B, they make contributions, do they not? Have you an estimate of how much Scotland would have to make, and would it come out of the block grant for Scotland? And they have to accept free movement of labour.
I haven't seen any attempt at a calculation of that.
Does not the Scottish Government include mention of that in its proposal?
I don't think in detail, but they include mention of a contribution, which I think there is an assumption in the paper that would come out of the existing UK contribution when it was repatriated, if you like, rather than the existing block grant.
Now, finally, you mentioned Spain. Are you aware that the leader of the ruling Partido Popular's delegation to the MEP said to the European Parliament on the 30th of January, the position of my party, which is the ruling party, and that of the government is very clear. We will not talk to anyone other than the government of Great Britain. There can be no special common market solution, as we call it, for Scotland. Spain is going to say no to any kind of special solution for Scotland.
The Partido Popular has very strong views on these issues.
And is the governing party.
Yes.
Thank you.
Well, I was... Pardon?
Just one question.
Well, yes, I will come to you, but Carl was next, if that's okay, Carl.
Thank you, Chairman, and I'll try to get my potential 10 minutes to stretch to nearer 20. I'm conscious that you've answered questions you've liked and maybe tried to duck questions you haven't, so I'll keep these as general as I can. Do you accept the model of democracy we have in this country? Obviously, we don't have an English Parliament. We do have an Irish, Scottish and Welsh grouping, but it was a UK referendum that we had a decision made, and we do have members of this Parliament from Scotland, Wales and Ireland, and therefore it is a decision that will be made here rather than made elsewhere, how we decide how Brexit goes.
Shall I take that?
We can set it in a legal framework, which is that the Scotland Act 1998, Schedule 5, Paragraph 7, says that international agreements, brackets, including EU, close brackets, are reserved matters to the UK Parliament. And that's why the notification of withdrawal bill is before this Parliament.
Super. So I presume you accept, obviously, the decision of the highest court in the land that we had recently?
Naturally.
Very pleased to hear it. Thank you very much. So finally, Chairman, I believe we've heard, Professor McEwen, you have a blog. You have to forgive me, I haven't read it, and I don't know if any of the three of you publicly declared for either side before the referendum. But do you accept that Brexit's going to happen, and therefore, going back to the reason that you're here, can you give us your best optimistic negotiating objectives for the UK as a whole as we withdraw from the EU?
Speaking for myself,
yes,
I do accept it is happening, and whilst I appreciate the interest of the committee that there is on the possibility of a differentiated Scottish solution, I have to say that my own interest lies more in the actual consequences of the EU's withdrawal for Scotland, and I hope the committee will at some point turn to that question as well. And in particular, I'm thinking about the protection of Scottish interests vis-à-vis decisions taken in London, which is an issue as old as the Union itself, the Anglo-Scottish Union as opposed to the European Union, because whilst there's a lot of emphasis on the powers that will go to Edinburgh, Cardiff and Belfast, the powers that will come to London are infinitely more significant. They're far more important. And there is a real issue, therefore, of the protection of the position of the devolved nations in relation to decisions which are taken in London, which will require, at the very least, I think, a much more thoroughgoing system of intergovernmental relations, extending possibly so far as shared decision making. And the other consequence that I would highlight is the question of parliamentary control over the subordinate or delegated lawmaking powers that will be a feature of the Great Repeal Bill. And I'm thinking in terms not just of Westminster UK parliamentary control, but also control on the part of the devolved legislatures as well. So these are issues which I hope you will come back to in the fullness of time.
Yeah, just to comment that the UK polity is increasingly complex, and I think it's if there is a shared interest in it staying together in relative harmony, I think that it's important that the institutions adapt to recognise that complexity. The issue, you talked about the absence of an English Parliament, and I think the issue of England and how England is governed will re-emerge as the whatever it is the Brexit agreement is implemented in light of some of the things that Professor Page was just saying. If there is to be coordination between the devolved governments and the UK government around things like common regimes for agriculture or whatever, without weakening the devolved powers, then that will have to be through the intergovernmental arena. And the institutions aren't there yet to manage that on an ongoing basis. And it does again raise the issue of who represents England within that type of forum. So I think there are lots of issues to be examined, and I don't think it's... Yes, this institution remains very important. The UK government remains very important for governing the whole of the UK, but the UK is much more complex politically than it used to be, and I think that needs to be taken into account.
Okay, Mr.
Yes, well, the Law Society, of course, was neutral on the question. We have 11,500 plus members, some of whom would earnestly want Brexit, some of whom would not, and some in the middle who would have varying views at varying times. So we were neutral then, and we are neutral now. You make the point that there is no English Parliament, but the House of Commons has made arrangements for English votes for English laws, and those are proceeding at the moment. So where that comes up, and that takes us back to the Sewell issue, because effectively applying the Sewell principles under that convention, that ensures that, as we know, where the UK Parliament is going to legislate in devolved areas, it requires the consent of the devolved Parliament. And a legislative consent motion is sought then, and the Speaker will apply that rationale to areas which fall within English law, if they were devolved matters under the Scotland Act, the Government of Wales Act, or the Northern Ireland Act. So I think it all means that that same Supreme Court judgment, which you were so earnest to get my assent to, examines the Sewell Convention too. And that, in its sense, says that the courts will stand back from the Sewell Convention. They are observers of the Convention. The Convention is a matter of politics, not law. But we know what the law is, because the court also identified that law, and the proponents for the cases for the Scottish Government and the Welsh Assembly Government were clear in accepting that the legal decision about the law in that area. So matters of convention are matters for you and your colleagues, and no doubt if there are tweaks to be made to English votes for English laws, then those will be made in due course.
Thank you very much for those answers.
Thank you. Sammy Wilson.
You were giving your evidence. You indicated that there would be if Scotland were to remain an arrangement were made for Scotland to remain within the single market, there would be implications for UK-wide trade, which of course is one of the biggest single markets for Scotland. Could you spell out exactly what those implications would be?
Well, simply that Scotland would continue to adhere to EU law, would continue to comply with EU law, whereas the rest of the United Kingdom would potentially be going in a different direction, adopting different standards and so on, which would then raise the question of barriers to trade between Scotland and the rest of the United Kingdom. It would threaten the integrity of the existing UK single market.
And would you assume then, from what you're saying, that
and that's one of the themes that, regardless of whether or not.
I assume what you're saying, those additional barriers would actually be detrimental to Scottish industry in relation to the biggest single market which is available to it.
Yes.
Are there also implications for initiatives taken by the UK government to support various industries which may have a UK-wide basis, that Scotland would be exempt from those because it might go against the state aid rules, which they would be still subject to within the single market?
I hadn't thought about that. Yes, Scotland would continue to be bound by, in theory at least, yes, the state aid rules. We were talking earlier about advantages or potential advantages of leaving the EU, and one of them is the freedom to pursue your own industrial policy, not subject to those rules. So yes, there would be that difference between different parts of the United Kingdom, yes.
Thank you.
Jonathan Edwards wanted to ask a quick question.
Professor Page, you mentioned in an earlier answer the issue of shared competence, and I've got to be honest, it's something I'm beginning to get my head around, because essentially the devolved constitutions as they work at the moment, things are either devolved or they're not. What policy fields do you think would have to be considered shared competence in the future? And the obvious one that hits me between the eyes is international trade, because you could have the UK government, for instance, making trade deals which have huge impacts on devolved competence areas. So what policy fields do you think might possibly, in a more flexible constitutional framework for the UK, might be deemed to be shared?
Yes, well, my general point is that one of the weaknesses of the existing devolution settlements is this question which Professor McEwen raised earlier of shared rule. We think primarily in terms of self-rule, which powers will go to Cardiff, which powers will go to Belfast, which powers will go to Edinburgh, and we leave the rest to, or reserve matters are dealt with in London. So if you apply the federal analogy, shared rule in the UK tends to be reserved rule. It's a matter for London. And I think we need to address that or think seriously about that in this particular context, because if we just continue down that road, we will simply build up tensions, difficulties between the constituent parts of the UK. So the intergovernmental system has to be made to work. There has to be a system without necessarily identifying particular powers, although there are areas, and the Welsh Government paper singles out international trade or agreements as one particular one, where that will be particularly important. And it's also important in relation to this question that I raised earlier of subordinate lawmaking powers, which will, where the question of the devolved Parliament's consent agreement becomes very, very important.
Thank you.
And we shouldn't underestimate exactly what an effort that is going to be. I mean, we are about to enter an unprecedented epoch of policy development and law reform, and not only the UK Parliament, but Parliament in Edinburgh and the assemblies in Belfast and Cardiff will have to be adequately skilled for that. It's going to be an enormous undertaking. The House of Commons Library paper, which identifies 20,000 or rather closer to 19,000 instruments which will need to be examined in terms of repeal, retain, amend. So that is something which will see many of you sitting around this table working on this for many years to come. And us too, because each of them will have to be consulted upon.
So I think there needs to be a GMC EU Law Revision Committee, which on which all parts of the United Kingdom are represented and which will have oversight over this process.
And I think but not Scotland, if Scotland remained part of the European single market. So
leaving that to one side for the moment.
It's rather important. They wouldn't be changing it.
Well, as I said, that's not where I started. That's not my starting point in relation to this.
Mr. Clancy, yes. Final word, yes, please.
The issue is, of course, that there are many options to deal with this further devolution, and we have to explore all of them, everything from a form of constitutional convention through to an enhanced JMC, which may be of the kind that Professor Page has described, but I would like to see that kind of enhanced JMC include bodies from civic society, from academia and others as present in the room, rather than have some kind of Smith or Kalman approach to this.
Well, one thing I think on which we can all agree is that any committee, joint committee, which is scrutinising all of this 19,000 bits of legislation is going to have its work cut out. We are very grateful. Unfortunately, we've run out of time because we're now going to hear from Michael Russell, the Minister, but we are very grateful to all of you for coming today and for helping us in our deliberations. Thank you. After my questions, I'm going to come to you first. Is that right? Is that okay? Good. Yes, of course. I shall add you to the list, Michael, of course. Okay, I can see that. Right, well, good morning. Can I welcome Michael Russell, who is the Member of the Scottish Parliament, Minister for UK Negotiations on Scotland's Place in Europe, and your colleagues, Ian Mitchell, Deputy Director, External Affairs in the Scottish Government, and George Burgess, Deputy Director for EU and International Trade and Investment Policy from the Scottish Government. You are all very welcome indeed, and can I thank you for making the time available to help us in our work. Can I begin, Mr. Russell, with the question of the single market? Because you set out very clearly, the Scottish Government set out very clearly in the paper that you published your wish to find a way of remaining within the single market, and that is clearly something that is been the subject of discussions in the Joint Ministerial Committee. The question I wanted to ask was about your understanding, perception of the attitude of the other 27 member states to this proposal being a runner, and in particular in terms of precedent. Because as I, and you quoted it in the document, Article 56 of the EFTA Convention says that any state may accede to the convention. Now, as far as I'm aware, unless you can tell us differently, there are no bodies that are not states that are currently parts of the convention. So how exactly do you envisage that working?
Well, thank you, and thank you for the invitation to be here. I'm grateful for the opportunity to give evidence to you. I think there are probably two answers to that, and with your permission, I'll give you both.
Please.
The first of those is that whilst there are presently no sub-states, there has been a long debate about the possible membership of the Faroe Islands, and that is also quoted in the paper. And it is likely that the Faroe Islands will accede to membership. through one of two possible routes, either through sponsorship by the Danish government or possibly through recognition as a legal entity. Now, both of those routes are possible for Scotland in its present condition. And that would mean either there would be sponsorship by the UK or the creation of a distinct legal personality for the Scottish Parliament, something, of course, that exists for the sub-state parliaments in Belgium. So there is a technical mechanism, but it won't be easy, and that bridges me into the other answer, which is to say that I think what I'm asking for in terms of consideration of Scotland's place in Europe is no more nor less than the UK government is asking for in their proposals, which are somewhat less substantial, I have to say. And that is to have the opportunity to put these on the table for debate and discussion with the others who are involved. You know, there are many commentators in Europe who will comment on some of the things, for example, in the UK government's white paper last week, to say those are not possible. They will not take place. But the UK government is saying, I think quite fairly, well, we will now go in and attempt to negotiate them. I believe the right thing with this document is for the UK government to say we may not agree with every detail within it, but we are going to place this in negotiation in order to see what we can do with it. And I think that would be the fair thing to do.
Okay, thank you very much. And the second question I wanted to ask was on free movement, because you, as I understand it, you've proposed that Scotland will wish to continue to operate that policy. And when you were interviewed on the Today programme recently, because you were asked a question about how it would work in relation to EU workers and migrants coming to Scotland and what happens if they then want to move to England, and you said that their passport or their documentation would in effect show they're only entitled to stay in Scotland. And the specific question I wanted to ask is, how do you envisage that working, and at what point would that documentation be issued to EU migrant workers? And we're assuming, for the purposes of this question, that those who are here now get to stay with all of their rights.
Let us hope so.
Indeed. Well, I think that is shared right across the committee and the country, and the government. They're saying that there's one or two member states that aren't quite keen on it yet, but we hope that they can be persuaded. But after that, at what point in the process would this documentation or this stamp be issued?
Well, let us start with the overarching policy, which is to say that this is something that exists elsewhere and operates successfully elsewhere in parts of Canada and parts of Australia. And indeed, I think the Scottish Affairs Select Committee of the House of Commons and recently the European Committee of the Scottish Parliament, in that case unanimously, have said that free movement of labour is very important to us and should continue. Now, the example I gave on Radio 4 is an example, and the paper deals in examples. But there are many things in this paper, as there are many more things in the UK government stance, that require detailed fleshing out, and that's the work that we continue to do and want to do with the UK government. But, Michael, David Davis gave an interview, I think, in Ireland before Christmas, in which he talked about what the problem of migration was. And the problem very often is not the border per se, and there will be a border. The problem is people overstaying their welcome, extending their visas without permission, things of that nature. And already, the way in which that is dealt with is in precisely the way that I am mentioning here. It's a matter of paperwork. It is provable that people have overstayed their visa, as a result of which they're not entitled to be here. And that is exactly the same situation. There is a rider added, which is to say that the place in which they can be employed, the place in which they can reside, is Scotland. And it's commonplace to do that. There are ways in which it is done elsewhere in the world. It can be done easily here. The reason we stress free movement of labour is because we believe it's important for the whole of the UK, and we reject the analysis of this that has taken place by others. But it's particularly important, we believe, in Scotland, given the ageing population, given the nature of the economy, and given some of the sectors that are very vulnerable, and also the issue of depopulation. I mean, I represent the constituency of Argyll and Bute, which is losing population faster than almost any other part of Scotland. We have a severe problem that can only be resolved by migration, and the best migration of all, the migration that's made the most difference in recent years, is that from other EU countries.
I appreciate absolutely that argument, but just on the point of the paperwork, because if the proposal that the Scottish Government has made were to be accepted, presumably the passports or documents of those who arrived after the cut-off date would have to say right to live and work, or right to work in Scotland only. Yeah. Correct. But the question I'm asking, just so I understand, which we're trying to explore the proposal, is at what point would that piece of documentation be offered? Would it be, you wouldn't do it when people arrived at Edinburgh Airport, but if they wanted to work, they would have to then make an application in Scotland. That's what I'm just trying to understand.
Well, you would do it at the point of entry, because you'll be doing it at the point of entry. I mean, this is now detail which we need to discuss and debate with people who are, dare I say it, convener, more knowledgeable than you and I on the details of passports and paperwork. But what we need to do, what will happen already, is that people coming from other European countries will pass through a border which is not the same as the borders we have now. That's axiomatic. So in those circumstances, I can envisage, but for debate and discussion, that would be the moment at which there would be that permission given in writing that that was what they would do. But we can certainly debate and discuss the precise way in which it operates, just as there are very substantial details, for example, in the proposal of the UK government, which now require to be very considerably fleshed out before we understand how they will work.
Right. So just finally from me, and then I'll call Seema Malhotra. If that discussion were to take place at the border, then, because I think we're all assuming, rightly so, that any EU citizen who wants to come for the purposes of tourism, we're not going to be talking about visas, does that mean that we might say in Heathrow need to ask people who are arriving, are you planning to come and work in Scotland at the point that they arrive at Heathrow, or is that yet to be determined?
Well, it's yet to be determined, but I have to say I'm not as confident as you are on the issue of visas. I see there is no agreement or even outline agreement on that issue. So I think we don't know enough to know how that will work. But we can say that in principle, because it works elsewhere, it is possible to delineate the place that people should live and work, and indeed that is presently the basis of enforcing restrictions on migration right across the board. That is the basis on which is done the written permission to do something.
Okay, thank you very much. Seema Malhotra.
Thank you very much for coming in as well to give evidence today. I want to just explore a little bit more how you think it will work if Scotland remains a member of the single market, but the rest of the UK has left. How do you envisage that actually working?
I'm having difficulty hearing.
Sorry, is that any better?
That is better, yes. Thank you.
I just wanted to ask if you could help us just envisage how it would work if Scotland remains a member of the single market after the rest of the UK has left.
I think the paper is, and I'm sorry to refer you to a paper of this length, but I think the paper is very clear about, in outline, how that would work. The mechanism chosen, and indeed there is a similar mechanism outlined in the Welsh Government's paper that was published a couple of weeks ago. The preferred mechanism is the EFTA-EEA route. Members of EFTA, and the convener has talked about sub-state membership and the issues surrounding that. Membership of EFTA, and through that membership of the EEA. And then you will have, the issues then become trade within this island. And what the paper does very clearly is say that if the UK leaves the customs union, and that was somewhat vague for a while, but I believe has been now set at rest by one of the trade ministers, if, as is now expected, the UK leaves the customs union, then Scotland should leave the customs union too. So you essentially have a customs union within this island. Now, the paper outlines how that will work. It outlines some of the advantages that would exist for both sides of the border, in actual fact, for that to be the case, the fact that there would not need to be a trading border. And I think that the proposal, therefore, is fleshed out well, but of course it now needs detailed negotiation, because we will only get the detail of it once we've had that negotiation.
And what could you envisage as some of the disadvantages?
I find it difficult to see disadvantages for Scotland in these circumstances. Certainly there will require to be work done to ensure that the customs union operates seamlessly, and there will be difficulties for the rest of the UK in coming out of the customs union in terms of the requirements, for example, on goods of origin which will be difficult for them. So I think for Scotland it will work well. I think it requires discussion and negotiation, but we have put a lot of effort into trying to find a solution that squares a circle. And it's important I make that circle clear. The circle is that the people of Scotland voted 62% to 38% to stay in the EU. Present polling would indicate that actually has increased in terms of support for the EU. So we are not saying that the rest of the UK should not leave. We accept and we think there will be big difficulties there. Our first proposal in here, as you know, was for the whole of the UK to stay in the single market. That has been ruled out. But we believe in those circumstances the circle can be squared. The outline proposal is here. The detailed negotiation needs to take place. And so far, I have to say, I'm disappointed that the UK government has not entered into that detailed negotiation. I believe they should do so, and I believe they should then take this proposal and put it within the Article 50 letter and within the process of negotiation.
Do you envisage, however, that there may need to be more investment in terms of border checks in some form between Scotland and England, and what scale might that need to be, and where would the investment need to come from in order to...
Well, one of the hidden costs of Brexit will be a major increase in expenditure by the UK on all sorts of systems for trading goods, because by definition they're going from a system that is free and open to a system, no matter what is negotiated, that will be less free and less open. So the UK as a whole will invest heavily there. The aims of this proposal is to try and diminish such a requirement for the Scottish-English border almost to vanishing point. Now, we use as an example Switzerland and Liechtenstein, different in scale but still same principle, and Norway, Sweden, which have some similarities to it. So, providing there is a positive approach to this, again, I echo the view of the UK government, providing we enter into this in a positive spirit, providing we can be imaginative, we think that those difficulties can be kept to an absolute minimum.
So, what challenges do you also envisage in terms of what jurisdiction Scotland might be under in terms of any trade or other related issues in relation to EFTA versus the rest of the UK? What implications that could have for, in a sense, the UK single market as we currently have it?
Well, as you will know, EFTA countries are able to negotiate their own trade arrangements. So if you give Scotland legal personality, which is the proposal in here which you would need, then Scotland is quite able to enter into those arrangements. And I'm sure, given the present trade between Scotland and England, they would want to make sure it was an open border and free and open trade. We've said that all along. The balance of that trade is interesting. England and Wales actually export slightly more to Scotland than comes from north of the border south. Part of the trade north to south is electricity, on electricity pylons, but this will be an open trading border, and everybody will benefit from that. I have to say again, precisely the same way as the UK government is talking about the rest of Europe and itself, hoping to have open trade. That's exactly what we would expect to happen.
If I could just probe this a little bit further. In that scenario, Scotland would be outside of the jurisdiction of the European Court of Justice, within the jurisdiction of EFTA Court, and the rest of the UK might be outside of the jurisdiction of the EFTA Court?
It would be. The position here is it would be in the EFTA pillar. So European Court judgments are not binding upon the EFTA Court, but are taken into account by what is a freer court, a much freer court. But I have to say I have no particular axe to grind on the issue of courts outside Scotland or outside the UK. We live quite comfortably in those circumstances, as I would contend so does the UK. It is a fact of life that there are courts outside one's immediate jurisdiction. I think the origins of this argument are very strange and lie in a Swiss argument of the 1970s about EEA and European membership, which in itself lies in I am told, in a misreading of Swiss history. So I think we should get off the hook of courts outside the UK. I'm quite comfortable with the EFTA pillar. I think it will give sensible judgments and will be well represented in it, as indeed the UK is well represented in the European Court.
So in your view, in terms of the trade links with the rest of the UK, which obviously is of great significance for the Scottish economy as well, you don't have any real concerns about what the implications would be of Scotland staying within the single market if the rest of the UK leaves?
No, none whatsoever. Indeed, I am unusually one with some of the Brexiteers in this. I believe in open borders and free trade.
Would there be any sectors, industry sectors in Scotland who would maybe have some concerns about that arrangement more so than others, and where might those industry sectors be?
Well, the sector that was most vocal in terms of exiting the EU was the fishing sector, and I represent a constituency with strong fishing interests. I understand that. The common fisheries policy was widely regarded as a substantial failure, largely because the fishing waters were traded away in the 70s on accession to the EU. As EFTA EA arrangement does not cover fisheries, that squares that circle essentially. It will not be part of the CFP. There are, I think, issues in agriculture because of the common agricultural policies to do with tariffs, which will require the UK to think very carefully about what happens next. But I think that this is no disadvantage. For all other sectors, I think it's pretty positive. And some of the business opinion that we see in Scotland remains very concerned about the effects of Brexit, and this provides, I think, a much better means of moving forward. I should stress, this is a compromise proposal from the Scottish Government. I really want to stress that. I don't think it will come as a surprise to anybody in this room, given that I am a member of the SNP of some 40 years standing, that I believe in independence. But we've worked very hard to put forward a compromise solution, which we believe respects the decision made in England and Wales, but also respects the decision made in Scotland. And therefore, this is a proposal made in good faith. We published it some 7 weeks ago, and we really do feel it's about time the UK government engaged with it with similar good faith.
One more question. Just in terms of any budget contribution for remaining within the single market if the rest of the UK leaves, how would you see that being discussed or negotiated?
Well, it must be part. We're not a negotiating party. We recognise that we're not a negotiating party in the withdrawal that talks about withdrawal. That we hope we'll be involved and consulted and participate. But in those circumstances, we would willingly agree to a recognised contribution, and there is a recognised scale of contribution undertaken for EEA countries. And I'm sure the United Kingdom government will pass back to us the substantial bonus that they claim that is going to be available in leaving the EU.
Okay. Now, I think John Whittington wanted to come in briefly on these points, and then I'm going to come to Peter Grant. Yeah.
I hear what you say about your being relatively relaxed about the jurisdiction of different courts, but you don't see any problem arising from the fact that ultimately Scotland might still be subject to a superior court to the Westminster Parliament, even though that is not the case for the rest of the United Kingdom.
No, I don't. Scotland has lived quite happily in circumstances where those courts exist. We presently have the Supreme Court, but I think a logical view of this does diminish the concerns. If you take this view to its logical extreme, then clearly membership of the ECHR is impossible. Actually, membership of the United Nations becomes pretty iffy because there's mandatory resolutions of the United Nations. I think it is an exaggerated fear, I have to say, and I have no fears about it whatsoever.
The other question I just wanted to press you on, your legal colleagues in the previous session talked about the thousands of regulations that are going to have to be examined in due course once the Great Repeal Bill has been enacted. And there may be a steady process whereby the burden of regulation south of the border becomes steadily less whilst it remains at the existing level north of the border. And that, again, is something which doesn't concern me.
Well, I would want to have proved to me, to be fair, that deregulation was going to produce benefits. And I'm no friend of over-regulation. I'm a former environment minister. I know the frustration of certain types of regulations. I know the convener does as well. But in these circumstances, I am sceptical about the bonfire of regulations that is promised again and again. There are examples, for example, where regulation is used. Mr. Gove and I debated in Edinburgh on Friday morning, early on, in front of a large audience, and we got on to medical trials, and we had a difference of opinion on this. Many of the large pharmaceutical companies looking at the issue of deregulating trials, are very sceptical about the promise and proposal to deregulate these trials. These trials exist for reasons of safety. If you are going to deregulate them and essentially merge the process of approval of medicines with the process of having trials, you will compromise on safety. So I think we have to be very sceptical that there is some mountain of regulation that can be dismantled, except where those who wish to dismantle it wish to dismantle systems of protection of workers, social protection and human rights. And yes, I am implacably opposed to that happening.
Okay, thank you very much. Peter Grant.
Thank you, Chair. Good morning.
Morning.
Colleagues, you mentioned the Scottish Government's paper, Scotland's Place in Europe. Have you had any response from the United Kingdom Government on that paper as yet?
Well, I think it depends what you call response. I mean, this paper was tabled at the JMC-EN, and I spoke to it at the January meeting. It was agreed that officials would take the paper away and consider it. The Secretary of State for Scotland asked for a meeting with myself and my colleague Derek Mackay 2 weeks ago, which we believed was to discuss the devolution aspects of it, and I should stress there are strong devolution aspects of it, but I still don't know what he wanted because he didn't bring forward any proposals. So what we are looking for is a response to this, and the response we would like, because it's always best to go into negotiations saying what you want to have, the response we would like would be to the United Kingdom government say, we don't agree with all of this, we don't agree with A, B and C, we do agree with D, E and F, but we're going to take this and we're going to put it, an element of this into the Article 50 letter, and we're going to have a discussion with the other 27 about the aspects of this to see what is achievable. We think that that would be fair, that would be a recognition of the different points of views, and would not be difficult to do. But there is a meeting of the JMC-EN this afternoon, and no doubt, I know the Welsh paper is being presented by my colleague Mark Drakeford, the Welsh member of the JMC-EN, and we will see what happens. I'm sure it will be mentioned again.
How many meetings of JMC-EN have there been?
There have been to date. Today is the 4th, and it meets this afternoon, though I'm afraid I could not tell you where, because such is the process of setting these meetings that I do not even know at this moment where that meeting is taking place. I think it's somewhere within the environments of this building, but we don't know.
And to date, how much discussion has there been at JMC-EN of the content of the proposed Article 50 letter?
None. And that is one of the major issues that we have to address. The Prime Minister said that there needed to be, there was desire to have an agreed approach to the triggering of Article 50. We have not seen a draft letter. We do not know the date of submission of that letter. We have not seen a paper that proposes a content for that letter. And indeed, the work programme for the committee, which we received this morning about 8:30, that is a forward work programme, which does not give an awful lot of time to consider it, does not have the actual formal consideration of that draft letter on it as yet. Certainly not in the March meeting, where I think we are to have, if I remember the terms of it, a deep dive into data protection.
So just to be clear, you're telling us that there's nothing in the work programme of that committee before the date that Article 50 is triggered that would involve the Joint Ministerial Council from discussing the content of the Article 50
The Article 50 letter is presently dealt with by means of a report back from the Chair. There is nothing on the agenda that says we are going to... Now, I've made it clear, and I made it clear at the JMC plenary, along with the First Minister last week, I made it very clear that I am quite prepared, difficult as it may be for both of us, to lock myself in a room with David Davis for a day or two to look at that entirely confidentially. That is an offer I think all the devolved administrations have made. We are very happy to treat this in any way that the UK government wishes to treat it, but we don't believe that triggering Article 50 can be done unless there is, or at least there has been an attempt to be, to get an agreement on the letter, and that has not happened.
How much input did the Scottish Government have to the UK Government white paper that was published a week or so ago?
None. I was promised a copy on Wednesday morning to have it in the afternoon. I received a copy 40 minutes before it was published on the Thursday.
Thank you. Am I right in believing that part of the terms of reference of GMCN are to seek to find an agreed response to the negotiations and so on? To what extent has that committee actually started to fulfil its terms of reference?
Well, I think there is an intention, certainly from the devolved administrations, to treat the committee very seriously and to endeavour to engage in discussion about what the position is. We won't agree on everything. There are very different positions around the table. The three devolved administrations are in different places on this, though there is a similarity of view, particularly between ourselves and the Welsh Assembly Government. But I think there's a very great frustration that exists, that we don't seem to be treated with either respect or concern. And that is worrying to us, because the JMC plenary has now met twice since June the 23rd. I don't think either meeting has really got to the nub of the matter, but there was an agreement in Cardiff last week to intensify the work we're doing. I can't honestly see much sign of it. I think there is an officials meeting due to take place tomorrow to look in some more detail at the Scottish paper. But, you know, that doesn't meet my definition of intensification.
Thank you. Just one other question, because I know that others wanting to come in. You've commented about the sort of different attitude to EU migration, for example, that exists in Scotland compared to some parts of the United Kingdom. What's the current attitude of the Scottish Parliament as a whole, as distinct from either the Scottish Government or the SNP contingent in Holyrood?
When the Scottish Parliament has voted on single market, voted on Article 50, it has shown a considerable majority in favour of the position the Scottish Government has taken. This paper was debated in the Scottish Parliament on the 17th of January, and again, a substantial majority in favour. Yesterday, we held a debate on Article 50, and I think 90 to 20-something, I would have to look up the figures exactly, were against triggering Article 50. So there's no exact unanimity on all the details, but there's a very strong view that Scotland has taken a different path and that needs to be respected. But I stress, this is a compromise proposal in that regard. You know, this is by no means something extreme. This is what we believe could work. And really what we want is the response on that basis.
Just for the record, because I don't know how many members of the committee would appreciate what the make-up of the Scottish Parliament is, the SNP are in a minority government in the Scottish Parliament. Am I right in thinking that yesterday's vote against Article 50, as well as being supported by the SNP, was supported by the vast majority of Labour MSPs, it was supported by the Liberal Democrats and by the Greens?
The vote was the SNP, the Greens, the Liberal Democrats, the Greens, and all but three Labour MPs. Three Labour MPs took a position in support of triggering Article 50, a sort of mirror image of what has been happening elsewhere.
Okay, thank you. Thanks, Chair.
Thank you for that information. Right, Stephen Timms.
When the Chairman asked you about the documentation to allow free movement into Scotland but not England, you said you couldn't really say yet in detail how it would work. So can I just put a suggestion to you about how it might work and see whether you think this would be satisfactory? And that is that there wouldn't be any documentation at all beyond the passport that people already hold. It would simply be that in Scotland the law would be different to in England. In Scotland, if you had an EU passport, you would be allowed to live and to work. Whereas in England, if you had an EU passport, you wouldn't be allowed to live and work. You'd probably be allowed to visit, but not to live or to have a job. Now, if that was the position, is there a reason why that might not work, or do you think that would work?
Well, I mean, I'm very happy to consider ways in which this could be implemented. The Scottish Government has that openness on it. You know, we don't have a monopoly of wisdom. We've put forward a series of proposals, but we have made it clear again and again, and you know, I'm very grateful for that, because that would be a possibility, a way to do so. There are issues there, I think, around the issuing of EU passports, but yes, There are a number of ways in which it could be done. So we are saying, in principle, we believe there are means to achieve this. The convener quoted my interview on Radio 4, but actually that is an issue which we could certainly consider and will consider within that. What we're presently doing, things move very fast in the world of Brexit, what we've done is issued what we think is a useful detailed paper. But then we are deepening and broadening that by further work. And we have a large council of experts, a very distinguished group. We have a number of many academics.
Can I just interrupt? Just on the particular suggestion that I put to you, does it look to you as though that would work, or might there be some problems?
Well, I think it's probably best to consider these things in detail. But my reaction to what you have said is it is very interesting and worth exploring.
I mean, it's not clear to me why it wouldn't work. I mean, there's obviously a bit of hesitation on your part. It might not work because of something. I'm just wondering what
it is my natural caution to make sure that I do not welcome things which I do not fully understand. But I do welcome what you have said, and it seems to me that it could work. And therefore, I'd be very happy to discuss it.
Right. There's nothing, though, that you would point us to which would require exploration about it, or no aspect of it that...
Well, it would all require exploration, because we're not going to come to any conclusion about this without a great deal of work and exploration. Yeah. But I'm not hostile to it in any sense, and I wouldn't want you to think that my lack of enthusiasm is anything other than a product of my ministerial caution.
Right. Would you envisage some sort of registration being required for EU citizens who were in Scotland exercising their free movement rights?
I don't know. I think that is something that would have to be considered. I instinctively, as a sort of civil libertarian, worry about it. But we want to keep it as simple as possible. Remember, if we can go back to first principles on free movement, the great beauty of free movement is it's simple to operate. It's not complex. If I may take an example that might illustrate that, the people who grow soft fruits in the Angus Glens and down into East Lothian, had years and years and years of difficulties in recruiting. Free movement greatly helped them because people could come in, stay for 6 months and go away again, and are now looking with dread at the idea of getting involved with the Borders Agency and special arrangements, because they think this will just be so complex that they have said quite openly the simplest solution for them is not to have people coming in, it is to move the bushes to Romania and to Bulgaria, and to grow raspberries and strawberries and blackcurrants and gooseberries there where the labour is, rather than go through that. Now, if you take that and write it large in other areas, for example, in the health service, in the financial sector, in tech and innovation, in higher education research, 25% staff in higher education research come from other EU countries and Scotland, and that is a world-beating sector. We are more cited than any other small country. In all those circumstances, this is an enormous increase in detail and paperwork for no benefit.
Right. Do you plan to work up a detailed proposal for how this could work, and if so, when would you envisage that being complete?
We continue to work up further proposals on the basis of this, and we will publish them from time to time, but we're trying to get...
can you give us an idea of the timescale when you would expect to have a proposal?
The first timescale in here is the Article 50 letter. We have to get an agreement of putting this on the agenda at that stage. But would you
expect to have a detailed proposal for how free movement into Scotland but not England could work by that point, the end of
Some of that will emerge from negotiation, if this gets to negotiation, but we will continue to publish and to add detail. I'm not going to tie myself to a specific date, but we'll continue to publish and add detail.
I mean, it does all sound terribly vague to me, but...
No, in fact, it sounds much, if I may with respect say, it sounds much more detailed and comprehensive than anything the UK government has published. I mean, I don't like to say, feel the length, but in actual fact, there's substantially more detail in here, but I'm not going to over-claim. I'm going to make sure that we deliver ideas which can be negotiated.
Right. I mean, you haven't given us any details at all about how free movement into Scotland but not England might work.
The paper gives you substantial detail, and we have indicated that negotiation will produce more. I go back to the point, and I make it, again, very clearly. I think it's only right that we are judged in the same way as proposals coming from the UK government. We have more detail in these than the UK government proposals. This is no more difficult to do, and what it does is retains what we have. And that's a very important issue. We're not asking for anything special. We're not asking for special treatment. We're retaining, in fact, we're not even retaining all of what we have.
Right.
And I think that's a fundamental issue.
I agree with you that we're not getting detail from the UK government, but I'm disappointed we're not getting a little bit more detail from...
Well, you have substantial detail in this paper, with respect.
Well, you haven't. I confess I haven't read the paper. I mean, if there is detail there about free movement, could you summarise it to us?
Well, it would take me some time. I could read it into the record, but I think it might be better if members had a chance to read it.
Right. Okay, thank you. You've made the point to us that there are a number of sort of comparable arrangements elsewhere in the world, and you've mentioned Canada and Australia. Can you just outline to us how those work?
Well, there is detail in the paper, and it does, it does benefit study. But I would, in Quebec, for example, let me give you an example. That in Quebec,
that would be helpful.
The Quebec administration many years ago decided to, the province of Quebec decided to build an aerospace industry. So they, with shared sovereignty at that stage, they had the opportunity to attract people from places that Quebec was not attracting people from, and the Canadian government was not admitting people from, in order to build that industry. They did that. And people had the permission to live and work in Quebec, but they did not have the permission to live and work in Alberta, put it that way. And that worked pretty well for them. They were able to do so. And this is not a complex matter. And I just think it's astonishing that there would be a view that this would be of such complexity that it could not be done. It can be done by the issuing of appropriate paperwork, and possibly in other ways which we need to explore.
Do you know what the paperwork was in the Quebec case?
No, but I am quite sure that we could find out and endeavour to get you a copy.
If Scotland did have a different migration policy from the rest of the UK, would you envisage the policy for non-EU citizens wanting to come into Scotland would also be different from the UK-wide policy?
That would not be the first change that would take place, but it is, if it works on the EU side, I can see no reason why it shouldn't work on other sides, but that would not be the first. We are focused in this paper on a solution to a problem not of our making, and we're trying to find a creative and practical solution.
Thank you very much.
Well, Seema, I think Seema Maharajah wants a very quick question, because I've got lots of members now indicating, and I'm keen to get everyone in, particularly those who haven't been able to ask questions yet. But very quickly.
Just a quick follow-up on that. I understand from what I've read of your paper as well that some of the solutions that you might propose in relation to this border issue and control of movement and essentially a different immigration policy in Scotland to the rest of the UK would rely on looking at maybe what solutions might be found for Northern Ireland and the Irish border, and there may be some, you would see some applicability for the Scotland-England border?
Well, I'm very reluctant to draw exact parallels there. There are very, very different circumstances in Northern Ireland. Nobody, it would be very foolish to deny that. And clearly there are issues in Northern Ireland which require very, very careful and sensitive handling. The general principle I would enunciate is this: that if it is possible to have a border with free movement of people and different migration policies on either side in one place, it must not be beyond the wit of man to have it in another place.
Okay. Michael Gove.
Pleasure to see you.
Very nice to see you again.
If we had a differentiated solution, and Scotland were part of the EEA and the rest of the United Kingdom were not, how would MiFID operate?
Sorry?
MiFID.
Oh, the database?
No, the directive that governs financial services.
Well, I think that will be an interesting issue for our experienced negotiators to put in place. It is quite impossible to say how every single directive will operate, just as it has proved impossible for the United Kingdom government to say how every single directive will operate. But it is important that we negotiate them one by one. And my concern is that if Scotland is disadvantaged by losing any directive, we should be able to say so and negotiate it.
So,
how do you? I mean, I'm grateful to the question. If there is a specific disadvantage, and you draw it to our attention, then we'll very much consider it.
Well, the specific concern is obviously MiFID governs how financial services operate. It specifies that each nation has to have its own regulator. Who would the regulator of financial services in Scotland be in this case?
Well, we would have to discuss with our friends in the United Kingdom government whether there would be a single United Kingdom regulator, whether there would be whether the European regulator would suffice, whether it be a Scottish regulator. That is a matter for detailed discussion. I'm not unhappy about that detailed discussion. I'm sure we can find a solution to it. You and I, in a previous incarnation, ran education systems north and south of the border in very different ways. But we've believed that there were rules and regulations that we could operate separately and effectively. I'm sure we can do that.
Who is the European regulator that would govern MiFID?
Well, I'm sorry. I know you want to go through a series of questions with me in which you want to prove what I know and don't know about MiFID. What I want to do is to say to you that I'm happy to negotiate those matters. I'm not looking at my smartphone, unlike you, so I can't look up who it is. But I'm quite sure I could were I to use Google.
But is there, I mean, you are the minister in charge of this, but is there a European regulator for MiFID?
Well, I'm sorry, with the greatest of respect, I'm not going to get involved in this, convener. This is not about what I know about MiFID. This is about what we are trying to negotiate with the United Kingdom government.
Okay. Which Scottish banks would be subject to the Capital Requirements Directive, and who would?
Okay, I'm quite happy to enter into a correspondence with you on every detail of financial services. I shall engage in this my colleague, who is a minister with responsibility for that. Okay. I am the minister with responsibility for discussing the European negotiations, and I'm happy to do so. There are, in other words, people better qualified than I to talk about financial regulation. And
I hardly think so. You are the minister.
But not for financial regulation.
Data protection. Data protection. Who would be the appropriate regulator for data protection in Scotland?
Oh, well, that's very interesting, because that will be a subject of the deep dive on data regulation and data protection that is taking place according to the agenda for JMC-EN next month. So we will be able then to have a much clearer idea of the right way to handle this within the negotiations, and I look forward to it. One of my worries, however, is that if we do not remain a member of the single market, we will not be able to take advantage of the development of the digital single market, which is a key issue.
Yes, but within that, who would be the regulator? Would it be the ICO, or would you set up a separate Scottish regulator?
We will be able to negotiate that as part of the process of negotiation.
So you don't know who would regulate financial services, and you don't know who would regulate data protection. What about medical research? Would the UK MRC continue to regulate?
I am quite prepared to provide a list of the things that I do not know. It will be a very long list, it seems. It will be a very long list. There are many things I do not know.
Good.
What I do know is that we have made a series of interesting and detailed proposals which we would like to negotiate with the UK government, with people on both sides who are experts in these matters, unlike you and I would hope that in those negotiations we would make progress. And, I may be part of those negotiations, but I shall have experts on the other matters with me.
Okay. On the question of procurement policy, if the United Kingdom leaves the European Union, Scotland stays in the EEA, and we in the rest of the United Kingdom choose, of course, no longer to abide by EU procurement laws, does that put Scottish companies at a potential disadvantage when bidding for contracts in the UK?
No.
Why not?
Because they will be competing on terms that will be agreed between the two countries, and that will be, you might as well say, that UK companies will be at a disadvantage competing for tenders in the rest of Europe, which I'm sure you would not wish to say.
No, but I could say many things, but the question is, how could you guarantee that Scotland would not be at a disadvantage?
How could anybody guarantee that UK companies would not be at a disadvantage? I know there is some great expectation that UK companies will suddenly be free of all restrictions. When they're tendering in Europe, they will be subject to European regulation, just as they are now. And in those circumstances, they might be at a disadvantage if they have deregulated. These are the conundrums, Mr. Gove, we have to resolve by negotiation.
Again, no answers. On the question of Scotland's contribution, Norway pays a contribution to be in the EEA. How much would Scotland pay?
It will make a contribution according to that which is set at the time as the amount required. And that will, of course, be by negotiation.
What would you guess?
Oh, I wouldn't guess. That would be very foolish. to guess on such a matter. Gosh, you wouldn't want to do that. No minister would do that, as you know.
In your paper, Scotland's place in Europe, the figure is 3.3 billion. Do you stand by that figure?
I stand by everything in Scotland's place in Europe as a basis for negotiation.
But you just told me that it would be that you don't know, and then the paper says it's 3.3 billion. Which is it?
I stand by every item in the paper, and I'm happy to negotiate them.
So Scots would have to pay £3.3 billion to stay in the single market.
If that was the price to stay in the single market, it would strike me as a small price to pay for the lack of dislocation which you and your colleagues are forcing upon this country.
Which budgets would that come from in the Scottish Government?
It would come out of the Scottish Government's budget.
Which ones?
It would come out of the Scottish Government's budget.
And
that's an answer, by the way, so I do know it would come out of the Scottish Government's budget.
No, you're fine, but it's quite a big budget. But we don't know whether it would come out of education or health.
Scottish budget.
Okay. Then finally,
we'll all have more money.
we have at the moment, as
Very
you know,
good point. I have to say that all that extra money for the NHS will no doubt pay for it.
well, it would be money that would go to the NHS, which is in England, not in Scotland. But there you go, because you'd be giving all that money to the EU.
We're
Final
still
question.
waiting.
At the moment, we get it when we leave. When rules are set within the single market, of course they're often set by a qualified majority vote. When we complete the single market in energy, would you be happy for Scotland's oil and gas resources, their allocation and their regulation, to be decided by qualified majority vote, with Scotland capable either being of outvoted, or indeed, if the UK are outside the EU, Scotland not having any representation at all?
Well, in the grounds that Scotland was a member, I'd be happy for Scotland to speak for itself in those negotiations, because I have to say the way in which Scotland has been spoken for has not been very effective for our national polity. Just ask Scotland's fishermen about that matter. In terms of other matters, I think that the continuing membership of the single market will be beneficial to Scotland. And I don't have this extraordinary fear of allowing anybody else to take part in discussions about issues. This is back to the obsession with courts outside the UK, and frankly, it strikes me as the development of a bogeyman to make up for the shocking inadequacies of the current government.
No, but you're happy to accept a single market in energy, which would mean that Scotland's oil and gas, the regulations governing it, would be dictated by qualified majority voting within the European Union, and Scotland would not only be capable of being overruled because it had no votes, it would have no effective voice.
I'm entirely happy about taking part in a cooperative and collaborative single market in a way that benefits Scotland in every aspect, frankly, rather than leaving it to the present situation, or even worse, leaving it to the type of Brexit which you and others appear to be encouraging, which would be utterly disastrous.
But how could Scotland defend the position of the oil and gas sector when it had no vote in an energy market?
How could we allow Scotland to be dragged out of the EU against its will towards the type of Brexit which you are proposing? That is a far worse scenario.
With respect, that's rhetoric and not an answer to the direct question.
Worse. Well, I don't think you have been short in rhetoric in your questions, so a modicum of rhetoric from me might be acceptable, convener.
But I've had no answer so far on who would regulate financial services, who would regulate data protection, who would regulate medicine, or how you would protect Scotland's oil and gas sector in the single market. People in Scotland listening to this will be deeply concerned that one of the most talented ministers in the Scottish Government cannot answer these basic questions.
You have had a range of answers on serious proposals. You may not have liked the answers, but you've had the range of answers. And if I could urge you to get your friends in the UK government, if you have them, to ensure that they take part in serious discussions, all these questions will be answered, firstly, to their satisfaction.
Right. Well, can I say, given that exchange, I'm beginning to regret I wasn't present when the two of you were debating recently. But anyway, be that as it may, Pat McFadden is next.
Good morning. You've said, Mr. Russell, that you're trying to square a circle here, and I understand the desire you've expressed for Scotland to stay in the single market. But we have had a response to this, haven't we? The government has said that it is its intention for the UK to leave the single market, and it's also said that it will, while it will meet with you in this JMC meeting, and you've had 4 meetings, and I've no doubt there'll be 4 or more, and all of that will happen. They've also said that this will be taken as a UK government decision. So given their policy intention, what are you going to do?
Well, I agree with the first of those, which is the decision has been made to leave the single market. And I regret that, and I also regret the way in which it was announced. The JMC was due to meet 48 hours after the Prime Minister's Lancaster House speech was due to consider the matter. It was, at least perhaps we could have been told. But the second one I don't agree with you on. I think that the potential still exists for this solution to be put into place. And I also think the rhetoric of those who say we entered as the UK and we will leave as the UK, forget the way in which the UK and its constitution has changed in the last 40 years. When we entered as the UK, we entered as the UK without devolved administrations, without the nature of dialogue in this country that we now have. I think, therefore, that we have to recognise that it is a different UK. And if it is to leave, then there has to be that recognition that it leaves as a different UK with the constituent parts taking a serious role and being involved in a serious way. And, you know, that is what we thought was promised. And we still believe that is what is promised. The Prime Minister came to Edinburgh the day after she became Prime Minister and said that she wanted to fully engage and fully involve the Scottish Government.
Sure.
And in those circumstances, we believe it is still possible, and we hope probable, that there will be a serious negotiation.
I understand the way the UK has changed in recent decades, but since you published this paper with this desire at the centre of it 7 weeks ago, have you had any response from any UK government minister, anyone in the European Council, anyone in the European Commission to say that they think this should happen?
Well, interestingly enough, the Secretary of State for Scotland said on television in Scotland on Sunday that he thought it was possible to have a differentiated solution. That remains, as I understand it, the position, and it is possible to have a differentiated solution. We've put a series of genuine proposals on the table. You know, if the United Kingdom government wishes to take them off one by one, that is its business. But the reality is they're on the table.
What I don't understand, Mr. Russell, is why the Scottish Government hasn't already called a second referendum. Because despite what you say about the Secretary of State for Scotland there, I mean, are you really telling the committee that you think there is a serious chance that the UK government will agree that Scotland stays in the single market while its policy is to pull Scotland out?
Well,
do you really believe that?
I'm a great believer in rationality. I believe these are a rational set of proposals. They are put forward in good faith. They have been worked on very hard, I have to say. And in all those circumstances, I believe they deserve a proper hearing and consideration.
They might be rational, but what chance have you,
well,
got of getting them?
I still harbour a naive belief that politics in the end might be a result of rational consideration and thought. I know that does appear naive, but I hope it might be the case. The reality is we have a set of proposals here which we believe are workable, negotiable, and we think the right thing is for them to enter into negotiation, and that's what we are seeking to do.
Thanks.
Okay, thank you. Jeremy Lefroy.
Thank you very much, Mr. Chairman. Just one fact. I have looked at the paper, and the figure of 3.3 billion refers to the UK as a whole, not to Scotland, as I understand. So I would imagine that the Scottish figure would be about 300 million, although that's not actually quoted. That's in directly from your paper, and I think that's an important correction, because on the record it was being talked about as 3.3 billion for Scotland. But my question is not about that, but I just thought it was an important correction to have on the record. My question is about the single market in services in particular. It has been said, both by the UK government and indeed by others, that the European Union has not been good at completing the single market in services. It's a question that I and other colleagues have raised time and time again with both the previous Prime Minister and this Prime Minister, and it's always been accepted that the European Union has been very slow at implementing a single market in an area in which the UK, including Scotland, is traditionally very strong. If Scotland were in as part of the European Economic Area and the rest of the UK were outside that, how would that affect Scotland's ability to boost its own services sector on the basis that the European Union will continue in its rather dilatory attitude towards the single market in services?
Well, even though the attitude might be defined by some as dilatory, it is a developing competence, and I think it's one in which Scotland could continue to profit. Because we would remain within the single market, it would be a good place for people to locate, to continue to build the service sector, and I think that would happen. There is a sort of negative, which if we don't continue in the single market will affect the service sector, and that is the free movement of labour. The dependence upon certain parts of the services sector on labour from elsewhere is quite considerable, and in those circumstances an attrition of the ability of the service sector even to service existing markets might be the consequence of leaving the single market. I don't think we should underestimate the way in which labour shortages will become a key issue in this debate comparatively soon. That is not to say, as the convener has indicated, that people will be sent home. We all profoundly hope that that does not happen, and it's time the United Kingdom government made sure it didn't. But there's not only will there be an impediment to people working, there will be a push factor, where people will say, do I really want to come and work here? Do I really want to make my career here? Because we're not talking, not even in the majority talking, about low-skilled labour that comes and goes. We're talking about people who contribute very considerably, both in the public sector and the private sector, and in the services sector as significant workers. So I think there is an opportunity that will grow within membership, because we won't be cutting off other trading opportunities. I mean, that's one of the fallacies of this argument, that in some sense it is an either or. We won't be cutting off either opportunities, we'll be continuing with some. And, you know, there are other parts of Europe that are building their services sectors too, because they recognise the need to do so. We would be foolish to withdraw ourselves from that at this stage, even though there's more mileage. It's actually not dissimilar to the point I attempted to make to Mr. Gove about the digital single market. You know, that has taken time to develop, but actually it's on the cusp of something big. And, you know, finding ourselves outside it will be very problematic for the tech sector, for example, in Scotland, which is a substantial growth sector that has produced major global companies such as Skyscanner, but also produced a very substantial number of smaller companies that are very innovative. And they rely on labour from elsewhere, and they rely also and will rely on the development of the digital single market.
Just one more question, Chair. You referred earlier to the specific problems that parts of Scotland have in terms of declining population. Is this something that you would see as different from the rest of the UK?
Well, I think so. I mean, I'm not an expert on the demographics of the rest of the UK, but I do know that I take an example from my own constituency. We have certainly in Scotland, there is a drift of population from west to east, and that is what's taking place. But in terms of the population as a whole, 90% of the population growth anticipated in Scotland comes from migration. And you know, if that is limited, then the population growth will fall. We need substantial population growth in the western parts of Scotland. My constituency has 23 inhabited islands. If we don't have that population growth, then we are going to lose services, because the effect of declining population is a decline in services. Places become less desirable to live, particularly for those younger people, those with families, those who can't get housing, and it is a process of gradual decline. We've taken in Argyll and Bute, on the island of Bute, a substantial number of Syrian refugees, and they're not only welcome, they're actually essential if Bute is to maintain a population. And I think you have to look at migration through that very different prism in Scotland and realise the positive benefit of migration in Scotland and the net economic contribution of migration. And that's a really important point. It's not a point that is got across regularly. But in Scotland, we need the population growth. We need population growth, not decline. And there is a net benefit from that taking place. And therefore, to stop it happening will be very problematic indeed.
Thank you. Thank you. Alistair Burt.
Thank you very much. In view of the problems of population and the like, do you think Scotland would have any room, say, to repatriate Scots-born journalists who now operate in London, who could be brought back to the west of Scotland, maybe to retrain as something useful, like an anti-midge operator or something like that?
Well, the competence of anti-midge operators is high. It takes a lot of training to do that. But should there be volunteers, we'd be happy to have them.
Well, I think we can probably work on that, but that seems like a good opportunity. In trying to coming back to the Joint Ministerial Committee, in trying to avoid the consequences of the very hard Brexit and WTO, etc. Clearly, during the period of negotiation, the government's determination to avoid that and seek a successful negotiation with the European Union will be influenced not only by this place but through the committee. Has it yet set up a mechanism for how it's going to deal with its part of that negotiation, so that there will be transparency with how the negotiations are going, so that at various stages the JMC would be able to give some sort of direction towards those negotiations to try and make sure we don't end up with no deal, but we do get a good deal?
It's an interesting point. The committee is established on essentially broadly two principles. One is to agree positions, and the other one is to have a form of oversight if those positions are genuinely within the negotiations, what's happening with them. And the person essentially who is the embodiment of that is the person who chairs it, David Davis. And I say absolutely openly, I find working with David Davis absolutely fine. I have no difficulty in doing so. I trust him to do that. I'm not sure that's, however, the best way for a committee to operate, that you simply empower an individual to take on the remit of the committee. In terms of the involvement of the devolved administrations in the process of negotiation, there has been no consideration of that, although it was raised at the last JMC plenary, in actual fact, by the First Minister of Wales, and it will be an issue now that needs to be discussed going forward.
Yeah. I think we'd be very interested in how that process works. It's going to be essential that it works here, so that there's some influence of Parliament on the negotiations, so we don't just get left at the end with a take it or leave it deal. And I would imagine that there would be different issues to be taken up by the respective members of the JMC. Do you think that at some stage it might be possible to let the committee know how this is developing and what your sense is of the relationship and whether or not it's working effectively? You could contact the committee in due course.
Yes, and I think the role of parliamentary committees here, in Belfast, in Cardiff, in the European Parliament committees are quite crucial. I think it's absolutely obvious that the committees of the European Parliament will insist upon knowing what is taking place, and of course they have a yes-no vote at the end of the process. I know that the Scottish Parliament committees, in the last week I've given evidence to the Scottish Parliament committee, to this committee and to a House of Lords committee, and I am quite happy to enter into those discussions from time to time, even the nature of discussions that we have had at occasions in this committee, in order to ensure that there is that knowledge of what is taking place. I entirely accept that negotiations should not take place with a running commentary, but that does not mean that they should not be accountable, and negotiators should not be accountable to parliaments. And I think they should be, and I think that should happen. And it may be useful for the committee on some occasion to have the principal members of JMC-EN together giving evidence, which might give an interesting contrast of view.
Peter Lilly.
We established earlier there's no such thing in European law as the single market. There is the internal market of member states, introduced by the Single Market Act, which obviously you'd like to belong to if Scotland were an independent country as a member of the EU. So I take it when you refer to the single market, you're referring to the membership of the European Economic Area, is that correct?
That is what the paper refers to.
Now, during the referendum campaign, the Remain campaign said repeatedly literally the worst possible outcome would be membership of the European Economic Area. It would involve us being subjected to European law, having no say in making that law, having no possibility of changing that law, having to make a net contribution and accepting free movement. So you're saying it will be good for Scotland to have no say in laws covering the environment, employment, social relationships and all the other aspects of European Economic Area, even though during the campaign we were told that was the worst possible outcome.
Well, I didn't say it was the worst possible outcome, so I don't take responsibility for that. But I have been, as you have been, at European councils. And as a Scottish minister at European councils, let me tell you what happens. Usually that Scottish...
With respect, is that relevant to being a member of the EEA? Because you wouldn't be.
Well, allow me to finish the answer in my own words, and then no doubt you can criticise those, but I want to make the point. The point I want to make is, as a Scottish minister, and I've been, for example, to Agriculture and Fisheries Council, you don't get to sit even in the front row, that is an official in the UK minister. You don't get to speak. And on one famous occasion, Fisheries Council, there was a discussion of the North Sea cod recovery plan, a matter that would affect Scotland as it's a North Sea nation. And amongst those who got to comment was the Luxembourg Fisheries Minister, not a full-time job. But the Scottish minister did not get to contribute. So whilst I do think being at the table and making the decisions would be a good thing, I think Scotland's present position illustrates that being in the single market through EEA would be better than being spoken for usually by UK ministers at the Council of Ministers.
So it's better to have no one speaking for you than to have a UK minister who hopefully will be acting in the interests of Scotland as well as the rest of the UK.
Were the present situation to continue, then for as long as it continued, I would regard that as desirable. I can see a more desirable solution would be Scotland's membership. But for the UK not to be there changes that dynamic. We must, to be frank, get the best we can out of a situation not of our making.
So though you've been a member of the Scottish National Party for 40 years, you're actually not very interested in getting back power to Scotland to have any say in, or any power to influence or change, any of the laws covered by the European Economic Area?
No, that's not what I'm saying at all. I'm saying that the argument that's been put forward in this referendum, particularly by those who argued for leave, argued a case which I think is thin. And the thinness of it actually is in paragraph 2.1 of the government's white paper, where it admits quite openly that Parliament has been sovereign during the entire period it's been a member of the EU and continues to be sovereign. This issue of taking back control, I'd love to take back control into Scotland. None of the proposals I have seen so far from the UK government, for example, on devolution of matters reserved to Europe, take back control to the devolved nations, unlike the promises that the Leave campaign made during the referendum. So I have to say, I think the words taking back control in the way you use them are not the way I would use them.
So you don't want to take back control?
I want to take back control in Scotland.
But
so
you
that
won't
Scotland
through the
decisions.
European Economic Area?
I certainly won't if the hard Brexit being proposed at the moment takes effect, because that will produce for Scotland a hard Britain.
I've noticed you don't answer the question. We had a trade negotiator, Shankar Singham, here, who said that it would not be one of the disadvantages for the UK of being a member of the European Economic Area was that we would not be able to negotiate trade deals involving services, which are of particular interest to the UK, including Scotland, because you cannot negotiate a trade deal covering services if you don't have control of your legislation covering services. Would you think that would be a bad thing for Scotland not to be able to participate in trade deals involving services outside the EU?
Well, I think the best situation is a situation presently to continue as we are. But that's not on offer. So I have to go for solutions that are not as good as I would have liked at present. And in the national interest of Scotland, as this paper says, we are arguing a reasonable and practical solution, which is not the best we could have, but is the result of circumstances forced upon us. So I'm not going to be an apologist for things I don't think will work as well as I would like them to, but I'm going to try and get the best possible situation that I can.
At present, the EU's trade deals tend not to include services because they're of not much relevance to most other countries up in the EU, not the same as they are to us. Unlike Switzerland, where services are important and its trade deals do include services. So you want to remain in a situation where the EU tends largely to ignore services and be in a position where you wouldn't be able to get any deals, including services, rather than participating in trade deals the UK might be able to negotiate with other countries. We had a meeting in Parliament the other day with the former trade negotiators from Australia, New Zealand, Singapore, Mexico, the United States and Canada. All have said they'd be very keen, their countries, to negotiate trade deals, possibly even a prosperity area for those countries where services were a major part. Would Scotland not like to be part of a prosperity area?
Well, it's a bird in the hand, really, isn't it? I mean, I don't want to be disrespectful to trade negotiators, but there are no such deals. There's no such deals at the present moment. The reality is that there's a developing trade in services in the EU. It is going in the right direction. It is positive for Scotland, and in the present circumstances, we are being asked to give that up for promises which have no great validity. The basic argument in this is quite simple. There is a huge dislocation that is going to take place, a huge dislocation. And there is absolutely no evidence that on the other side here are huge advantages. Now, if you can prove, if those advantages are proved, you can ask endless questions about detail of this. Prove the advantages, and people, no doubt, will follow. But if you can't prove the advantages, then I have to say people will increasingly, as they are, looking very sceptically at this and saying to themselves, this is going to be huge cost for very little gain. And that's the reality.
Just finally, on the issue of what your document says about the possible contribution Scotland will make, I see that is based on the assumption that related in some way to what Norway would pay. I looked up what, in fact, the Remain campaign's fact correction blog said during the campaign, when it said if we were foolish enough to, they didn't use those words, but if we were to join the EA, we would have to pay an amount exactly equal in pounds per head, £96 per head, as the Norwegians. I notice you've adopted a different methodology now than was adopted during the campaign. Any thoughts about that?
Well, I'd stress that paragraph 103 says exactly what will be contributed if we opted for EEA membership would depend on negotiation over the contribution. And that's the position in the paper, and that's the situation. There will be speculation on this. But, I think the kindest thing I can say about Remain and Leave campaigns is not everything in a political campaign appears to be true. The trouble with that is quite a lot of the Leave campaign stuff was not only untrue, but it's going to cost us an enormous amount of money.
Now, I've got four colleagues indicating, and I'm very conscious of the time, but I've taken all of those who hadn't contributed in the first session. So, Jonathan Edwards first, and if you could be brief in the questions and the number, that would be helpful.
Well, just one quick question. We've got a situation where the Scottish Government and the Welsh Government, the Scottish Parliament and the National Assembly for Wales all want to keep our countries within the single market as full participation or membership or whatever term you want to use. Working on the assumption that the UK government aren't going to listen to those demands, and I admit I'm perhaps more cynical than you, and I've probably been down here far too long, what sort of mitigating factors are the Scottish government looking at in terms of measures that will be needed to protect the Scottish economy following a hard Brexit? Would you be looking at VAT powers, corporation tax powers? We've already discussed immigration, and we had a very interesting discussion in the first session about the need for the constitutional framework of the UK to alter considerably, rather than the matters being devolved and non-devolved, towards shared competence in areas such as international trade. Are the Scottish Government looking at those?
Well, I don't want to say anything in terms of the overall objective, short of saying this is on the table for negotiation and we want to negotiate it. But the paper does deal at paragraph 176 onwards about detail of competencies that need to change. And they broadly fit into three areas. The repatriated competencies that we would expect to have, indeed the Leave campaign said we would automatically have, if we left. And those are in areas like agriculture and fisheries and a whole range of other areas that are presently devolved. And, you know, now we are hearing a very different rhetoric on these, the rhetoric we were hearing during the campaign. The word automatic has dropped from the lexicon, and now we are told that nothing must interfere with the so-called single market in the UK, though that is actually a unitary market, not a single market. And in these circumstances, you know, we believe that that needs to be honoured. Secondly, the repatriated competence in reserved areas. Those things that we believe are at risk from leaving the EU, citizens' rights, employment rights, we think those should be devolved. And finally, the additional powers that we would need in order to become a member of EFTA and the EEA. So those are well laid out. Those are the things that we would hope the UK government would enter into discussion about. But we've put those on the table.
Okay. Mark
In respect of the Great Repeal Bill, first of all, will Scotland need any equivalent reception legislation of its own underpinning any particular rights? And in relation to the questions of consent, do you see Scotland, the Scottish Parliament, as just giving consent to the overall Great Repeal Bill, or would you seek a more articulate approach in relation to legislative consent, that it's legislative consent for each specific area that changes the competence of the Parliament?
Really important questions on what the process will be. The agreement presently is that there is no agreement. There are two possible routes. One is a substantial legislative consent motion, detailed item by item. This is the route I think the UK government prefer, but it's not. I should stress we have no agreement on it. It is possible, and indeed in some areas would be desirable, to have separate Scottish legislation, particularly on areas that will be devolved back to Scotland. Otherwise, you know, we do think things might tend to stick in Westminster. So the reality is that we are looking at both of those options. This is an enormous task. You know, as you, as a committee, will know, it's not a single piece of legislation. It is many pieces of legislation, and then there's a question of how things change. So it's going to create quite a legislative burden for a period of time. It will be difficult enough for Westminster. There are obviously issues that apply in Scotland. In all those circumstances, it's a discussion still underway. The data gathering is well underway. You know, and there has been work between the administrations, all four administrations, on that. But the final solution of where this goes has still to be found.
Joanna Church.
Yes, thank you, Mr. Chairman. Just a brief clarificatory question. A figure was put to you by Mr. Gove of 3.3 billion, and I think Mr. Lefroy pointed out that it comes from paragraph 103 of Scotland's Place in Europe, and that figure is an estimate of what the UK as a whole's net contribution would be if the UK was to stay in a single market through the EEA mechanism. That's correct, isn't it? And that's based on figures from the Institute for Fiscal Studies.
It is indeed.
And it says if contributed and received back the same proportion of national income as Norway, the UK's net contribution would be around £52 per person, 3.3 billion in aggregate per year, compared to a net contribution to the EU budget of £121 per person per year if you remain in the EU. So for the record, that's the correct figure.
Indeed, and that is very helpful. It just shows that asking questions in a constructive way gets the right answer, because that's exactly the correct answer. But can I add one point? There is of course a point that needs to be borne in mind of the cost of not being in the single market. And you know, best estimates on that, and there are many of those estimates within the paper, indicate, for example, the Scottish GDP would be up to £11 billion lower. It shows that up to 80,000 jobs would be lost. It shows average wages have dropped by about £2,000. So actually, the cost of contributing to the single market would seem a bit of a bargain